afternoon, we'll just get straight into it. We have a conversation arranged about the Supreme Court, meaning the Supreme Court of the United States. As a state Supreme Court justice, I feel like it's important to clarify sometimes. Our two panelists are, in addition to being very frequent lawyers, arguing cases before the Supreme Court, also share the distinction of also having served as Solicitor General of the United States. We have Seth Waxman, who is Solicitor General during the Clinton administration, and Paul Clement, who is Solicitor General during the George W. Bush administration. So in some ways, this conversation this afternoon is kind of two conversations for the price of one. We're going to spend some time talking about what it is to be Solicitor General of the United States, and then turn to some current developments at the Supreme Court. And there shouldn't be anything there to talk about.
I guess I know one topic we're going to talk about.
Before we get the questioning underway, we're also going to try to leave some time at the end for questions from the audience. But we wanted to just take a moment to reflect on the day. Today, May 15th, would have been the 81st birthday of Walter Dellinger, who we lost this past February. Walter was, in addition to being a former Solicitor General, was also a valued mentor and teacher and supporter and booster to many people in this room, and a dear friend and colleague to all of us here this afternoon. And so, as much as we're glad to have this chance to be together and to talk to each other this afternoon, it's also marked with sadness in missing the presence of Walter here with us. As we get our conversation started, I'm going to start off with a very basic question that could easily occupy us all day, but we're going to try to keep this relatively brief. Seth, in a nutshell, what does the Solicitor General of the United States do? What's the job?
Okay, in a nutshell, the Solicitor General of the United States has some enumerated responsibilities. The first is to represent the United States in the Supreme Court of the United States. That is, to decide which cases that the United States loses should be the subject of a request to the Supreme Court to take the case and review it. With respect to cases in which the United States has won and the other side invokes the Supreme Court's jurisdiction, what response the United States should give. And with respect to cert petitions filed by private parties, or in any event, parties that don't involve the United States, when and whether the United States should express the views of the United States in an amicus brief, either at the petition stage or on the merit stage, and what position should be taken. That's sort of the role of the Solicitor General that most people are familiar with. But there are a couple of other really important, I would say equally important roles, particularly the responsibility of the Solicitor General to decide which of the thousands of cases or decisions the United States loses, or the United States or its agencies lose every year, should be the subject of further review on appeal. That is, with a couple of limited agency exceptions, neither the United States, a lawyer for the United States or a United States agency cannot appeal a loss in a district court to the Court of Appeals unless the Solicitor General approves in writing. And I think in terms of the day-to-day, week-to-week allocation of time that a Solicitor General applies, that one is probably the single most significant, requires the most significant expenditure of time, because although the United States does win lots of cases and lots of motions, it's a party to over 100,000 cases at any point in time. And consequently, I think, Paul, it was probably true in your day, but I'd have 6 to 8 packets of appeal recommendations every single day. And many of them you could easily approve what the staff recommendation was or what the components' recommendations were, but a significant number of them are tough. and require a lot of thought. The Solicitor General also has sort of choke point control over amicus filings by the United States and most of its agencies in the lower federal courts. That is, where somebody else, like the Civil Division or the FCC, is has subject matter responsibility and would like to file an amicus brief in a non-government case where principally the constitutionality of federal action or a federal statute is raised, the Solicitor General has to approve it in advance. So that's sort of, I mean, the theory of this whole thing was to have one institutional person, one institutional entity in the Department of Justice that would have a say over legal positions that were being taken in court on behalf of the United States or its agencies, so that ideally you could have the ideal is that any lawyer for the United States appearing in any court, in any kind of proceeding, that is asked a question by a judge about the meaning and application of federal law will give the same answer. That's the reason, in order to achieve that, was the reason that the Solicitor General's office was created in the wake of the Civil War. And this is sort of how it's done.
So it's interesting to hear you sort of describe what the day-to-day work of the SG is, because I think when people often think about the job, they think of the most visible part of the job first, which is the arguments before the Supreme Court. But those are sort of 30 minutes a pop, where so much of the rest of what the SG does involves deciding what the positions government attorneys are going to take in court will be. I'm wondering, Paul, if you can speak a little bit to the process of how those determinations are made.
Sure. Well, it's great to be with everybody, and it's absolutely right. The arguing the cases in the Supreme Court, that's what is the most public role. That's what a lot of people think is the role. But not only is it just like the tip of the iceberg, but in a way, as Seth was saying, I actually did the math once, and it is like 6.5 of these packets every day, including weekends, comes across your desk. And what that means is the oral arguments in the Supreme Court are not just like the tip of the iceberg. They're also something you sort of have to do on your free time, because you really almost like the other parts of the job consume all of your working time. And when I was in the office as the SG, almost all my argument prep was done on the weekends as a result. But as to the process of trying to come up with the position of the United States, there's no there's science to it. There's a process, and as in many things, you sort of have to trust the process. And where I think it's most interesting is in a case where the court grants certain case that's a non-government case, and then the government has to decide whether to get involved in the case, and if so, on which side. If it's a case where the government's been a party, in a sense, the point cert gets granted, it's kind of too late. Either it was your idea to seek cert, which it still may be too late, but at least you asked for it. Or it's a case where the government filed a brief in opposition and it got granted anyways, which usually means that somebody in the office is going to be in for a rude morning a couple of months later. But the real kind of fun is when the court grants a case that you know nothing about. And what typically happens, the process in those cases, is the office notifies literally almost the entire executive branch and says, this case got granted. If you have any interest in it, let us know. Give us a memo. And sometimes it's super obvious. There's a case that's, even though it's a private party case, is really about the validity of a particular agency's regulation. That agency cares very much. The rest of the federal government cares very little. And you involve that agency in the process of trying to figure out the position, but it's all pretty straightforward. Where it's really interesting are the cases where the federal government's interests are far more diverse. The classic example of this, though it's by no means the only situation where this arises, but the classic situation is if the court grants cert in a case where one of the anti-discrimination and employment statutes is involved. Could be really anyone, age discrimination, disability, race, gender, wouldn't matter. Because what makes those cases so interesting is there's part of the Justice Department, the Civil Division, that is responsible for defending the federal government as employer. Federal government's the nation's largest employer. Most of the private sector anti-discrimination statutes apply to the federal government as employer. So in a typical case, the Civil Division writes a memo that says, boy, this is a really important case. We need, as the United States, to file a brief. We have to support the employer. So far, so simple. But Civil Rights Division probably also has enforcement responsibility over that same statute as it applies to state and local governments. The EEOC may have an administrative role over that same statute, and those two parts of the federal government are quite likely to send a letter over and say, hey, this is a really important case. We should definitely file a brief, and we should definitely support the employee. And then that's where kind of the art comes in, I think, of getting everybody together in the room. You hear from the employer, you hear from the employee and their lawyers, but then you gather together with just the government lawyers in the room, and you have an extended discussion, and then out of that discussion, the Solicitor General has to make a decision about what the brief of the United States is going to say. And in some cases, you sort of pick one side versus the other based on the strength of their position. Maybe the Civil Division has had this position, but they've never really taken it in court much, whereas the EEOC has their position embodied in a manual that's subject to some deference. Or in another case, you may try to have your cake and eat it too, and come up with one of these beautiful compromises in the middle, where you end up getting 5 minutes from the argument from each side and straddling the fence and making nobody happy. But those are the cases, I think, in some respects that you really see both the process and you see the idea of the SG's office, where you really are trying to communicate the overall position of the executive branch to the Supreme Court, and that overall position of the executive branch, really sometimes is the product of subparts of the executive branch that have very different views on the issue.
So one interesting component of the SG's decision-making process is that the SG is not only sort of mediating disputes between different components of the executive branch, but it also, in addition to its responsibilities to the court, also has this so-called duty to defend. It has responsibilities to the Congress of the United States. And wondering, Seth, if you can talk to us a little bit about the duty to defend. What does it mean? What does it entail?
Yeah, I certainly can. I mean, this was such a perplexing duty to me when I became Solicitor General and was put in the position of, not only in the Supreme Court, but also in the lower federal courts of honoring the principle that, if there is a reasonable argument to defend the constitutionality of a federal law that's been challenged, that does not involve asking the court to overrule a directly on-point precedent, it is expected and institutionally important for the Solicitor General to put on that defense. And I actually spent a lot of time looking into the history of this duty and the foundations of it. And I actually, gave a lecture at UNC and published an essay about it in the UNC Law Review. It's really, really interesting. But the notion is the fundament is that there is that both the executive branch and the legislative branch swear to uphold and defend the Constitution and laws of the United States. They have their own obligations to do that. There is therefore a presumption that legislation that is enacted by the Congress and signed by the President, or enacted by the Congress and a presidential veto is overwritten, are in fact constitutional. And we have an adversary system of justice in which it is ultimately up to the judiciary and not the executive or the legislative branches to render the final decision, so long as Marbury versus Madison is still good law. And therefore, the role of the Solicitor General in this regard is to provide the best possible arguments for the constitutionality of a challenged law, so long as there is no duty if the defense of the constitutionality of that law requires telling the Supreme Court that it needs to overrule one of its settled precedents. And that's essentially how I understand it.
And so how did, sort of practically speaking, during your tenure as SG, how did this come up?
It came up, in a number of cases, in which, in some instances, the civil division, had litigated successfully or unsuccessfully the constitutionality of a challenged law. And when the question came up about whether we should authorize the appeal or whether we should invoke how we should respond to a Supreme Court cert petition or invoke the Supreme Court's jurisdiction, the SG has to make an independent decision about whether there are, in fact, non-frivolous grounds for defending it consistent with established precedent. And there were a number of instances while I was SG in which, we decided that there were not, in fact, non-frivolous grounds for continuing to defend the constitutionality of this statute in light of what the Supreme Court had held in analogous circumstances. And there's a law that requires that when that is done, the Solicitor General has to advise in writing the legal counsel of the Senate and whatever it's called, the bipartisan leadership, something, the correlative organ of the House of Representatives. It also came up in a number of instances in which, I got up there and made the very best argument that I could for the constitutionality of a statute that sure seemed unconstitutional to me. And, I have to say that in all but one of those cases, a majority of the Supreme Court justices decided. Probably the most notable example during my tenure was the case of Dickerson versus United States, which Dickerson was an accused bank robber. He had been questioned in his home by the FBI, and then subsequently went down to the local headquarters and gave another statement. He was prosecuted for bank robbery. The government sought to admit certain of his statements that he had made, and he argued that they were inadmissible because he had not been given his Miranda warnings, and he said he was in custody. The government in the trial court argued that, and lost. There was an appeal recommendation from the Assistant United States Attorney to appeal that to the Fourth Circuit, which I evaluated and approved, but which failed to mention anywhere in the U.S. Attorney's write-up that there was this Miranda issue in the case, and that, in fact, it was conceded that he had been in custody. So an appeal went through, and the Fourth Circuit reversed and basically said, we're a government, we're an institution of laws, not politics like the Justice Department. And, there is a statute on the books that was passed as part of the 1968 Crime Control Act that says in federal courts, custodial admissions statements are admissible so long as except and only except if they violate the Fifth Amendment of the Constitution itself. And, Miranda is dead to us, basically, is inapplicable here. And I decided after a long, long process to let the bank robber, the accused bank robber petitioned, and I advised the Supreme Court that the United States would not defend the judgment of the Fourth Circuit. That is, we would take the position that a custodial statement that, by somebody who had not been given Miranda warnings was inadmissible in federal court, even if it was not involuntary under the Fifth Amendment. The then chairman of the Senate Judiciary Committee, the late Orrin Hatch, who'd been a personal and professional friend of mine since I represented him when I was in private practice 20 years hence, made a public statement, quote, wanting to remind the Solicitor General that he was subject to impeachment for failure to defend laws of the United States. But we went through, the most detailed sort of executive branch process. I could not understand how Miranda was not constitutionally based, because I didn't understand how otherwise Miranda versus Arizona could have applied an exclusionary rule to a state prosecution. And therefore, it seemed to me it had to have constitutional underpinnings. And other than asking the Supreme Court to overrule Miranda and the 36 post-Miranda type decisions. And so I sent out a memo to all of the heads of all the federal law enforcement agencies and every one of the 94 U.S. attorneys, and asked them to, if they had, not views about the constitutionality, but views about the extent to which the Miranda doctrine was an impediment or an assist or helpful to federal law enforcement. And I got very, very thoughtful memos from each of the federal police agencies. The Attorney General and I went to the Justice Department's sort of convention meeting center in South Carolina, had a meeting with all the U.S. attorneys. I obviously consulted with the Attorney General. The Attorney General said, we are not going to abandon Miranda versus Arizona. The Deputy Attorney General thought that we should. And I said, I think, thinking about the organization chart of Title II of the Constitution, maybe we should make sure that the president is okay with this. The president was somebody, Bill Clinton, among his many other characteristics, had previously been a constitutional law professor and tended to get very involved and interested in things like this. So we went over to the White House and met with the Attorney General, and the Deputy Attorney General and I went over and met with the president and counsel to the president in the cabinet room. And, I made the case pro and con and said, this is what I believe. I don't think there's a reasonable argument to defend the Dickerson decision, and I'm not going to, unless you tell me otherwise. And he leaned over and said, I wasn't elected to overrule Miranda versus Arizona. You tell me what you need to protect you politically from this impeachment talk. And so we went ahead and, in the end, won the case in an opinion written by the Chief Justice, which seemed like a vindication. So Paul has had his own set of experiences, some of which I know quite well, having been involved in those cases.
Yeah, I would love to hear your experiences with the defense of acts of Congress, particularly, I guess, in these situations where you are part of the executive branch. You do sit underneath the Attorney General and, of course, the President on the org chart. And sometimes, the executive branch may have a view of a particular piece of legislation that doesn't coincide with the majority of Congress.
Yeah, so every time I hear Seth or Walter, when he was with us, talk about sort of these meetings at the White House with President Clinton, I think, wow, it's not the same in every administration. And I can tell you, I think the biggest difference is not Republican, Democrat. I think it is whether the president was a constitutional law professor. Because, President George W. Bush was not a constitutional law professor, wasn't a lawyer, had a very different perspective, very different amount of time allocated for these kind of meetings. So it was kind of a different process. Most of the time, in most of the cases, it works in a pretty streamlined way. I'll just give you sort of one kind of example of a kind of relatively non-controversial sort of duty to defend issue, which is when I was acting Solicitor General. So kind of in that sort of position where you're kind of a little bit nervous because you don't actually have a permanent job. But a recommendation came across my desk, and it was an appropriations rider. And anybody who's a student of Congress knows that there's one level of thinking that goes into the laws that go through the committee process, and you can think that's either really high or really low, but there's a level for the things that go through the process, and then there's a different level for appropriations riders, which can just be slapped on at the last minute. And so this was an appropriations rider that basically said that recipients of U.S. Funding for transportation projects could not run advertisements on like the bus services or the metro services that were pro-drug legalization. And First Amendment scholars have a term for that that's called viewpoint discrimination. So it was okay to run an ad that said just say no, but not an ad that said just say yes. So the Justice Department gave it their sort of college try in the trial court and lost spectacularly. The appeal recommendation came across my desk as acting Solicitor General, and I thought, this is just not defensible under anything like current law. Jotted off that letter to Congress and really didn't hear anything about it. It was a very kind of non-controversial decision. The only reporting of the decision I ever came across is then when I was getting ready for my confirmation hearing, somebody did a little bit of research, was what's out there about this Clement guy, and they came across a very sort of pro-legalization group that was lauding me as the only person in the administration who got it. The rest of the Bush administration jackbooted thugs, but this Clement guy gets it. Not really true, but what the heck? In the confirmation process, any support is good support, I suppose. But then you have these ones that are just bigger profile issues, and obviously for Seth, 3501 and Miranda was a very high profile issue. Probably the highest profile issue that we dealt with was the Bipartisan Campaign Finance Reform Act, or McCain-Feingold. And in the end, it wasn't really that hard a decision to defend the law because President Bush had signed it into law. So this was not some sort of ancient statute signed into law by another president where everybody in the administration, the current administration, thought it was unconstitutional. But there were a lot of people in the Bush administration that weren't super excited that President Bush signed the Bipartisan Campaign Finance Reform Act into law. And I think it's fair to say that there were probably a majority of the political appointees in the administration were rooting against us and hoping we would lose. But there was kind of an early decision to defend, which was actually made by Ted Olson. I was the deputy at the time, but what he told some people in the administration is I was stuck with me, and I think to me it sort of shows kind of like the Justice Department at its best, which he said, look, ultimately the president could tell us to not defend. I mean, it's his decision ultimately. We looked at the org chart too, and we did see this one elected official at the top of us, and the rest of us aren't mentioned. So he could tell us not to defend. But what Ted said is, if the decision is made to defend, don't bet against us. And, what he was trying to convey is we don't have two speeds here. We don't have a sort of going through the motions. And like Seth, I had cases where we decided that the duty to defend meant that we should defend, but, it seemed like a very difficult defense. But in this one, it seemed like a very difficult case that the court was probably going to decide 5-4 or 6-3, one way or the other. And when the decision was made to defend the act, we really did give it our all, and it was a full court press. And Ted and I split the argument along with Seth, who was representing Congress, and we did win in the end. And I think that it was, like I said, I think when the Justice Department defends an act of Congress and against a constitutional challenge, and it's a little bit at odds with the kind of political valence of the administration, I kind of think that's the Justice Department following the best of its traditions. I think, one of the things that all of us, when we talk about the courts, we talk about law, we need to explain to people how it's different from politics. And to me, the duty to defend is one of those things that you can point to in those situations and say, look, this is it wasn't that this Clement guy got it on drug legalization. It wasn't that the Justice Department was out of control by defending a campaign finance law in a Republican administration. It's, that's what lawyers do.
So you have this job where you are representing the United States before the Supreme Court on a regular basis, balancing all of these many considerations, sort of trying to vindicate the institutional interests of various components of the executive branch, trying to be candid with and helpful to the court, sort of fulfilling the duty to defend. When you started arguing cases in private practice after you left the office, was it just an incredible relief? Just like, oh, thank goodness, I only have one client to worry about now.
Well, I don't know that it was an incredible relief. It's sort of, exhilarating, empowering, and demanding to know that your job is to represent the interests, the long-term institutional interests of the United States in a Republican form of democracy. I mean, that's a lot different than standing up in front of the justices and saying, Your Honor, I'm not sure that you're fully understanding. This is the view of the Ford Motor Company. On the other hand, the other thing that was, I suppose, less than exhilarating was when you're Solicitor General and you have to decide what the position of the United States is, and this was often the case even in terms of authorizing appeals, you can say to, for example, some United States attorney that has lost, a really important criminal case based on a ruling that is just wrong, that, look, you were right, the position you took was right, and the Court of Appeals was completely wrong, but this issue will come up over and over again, and this is not the right case to take to the Supreme Court. It's not in the long-term institutional interest of the United States to do this. It's similar to a conversation that I had when I was Solicitor General when we were called upon to interpret a law that Congress passed that was called the Treasury Amendment. And the Commodities Futures Trading Commission and the SEC had one view, and the Treasury Department had another view, and I decided that the former was correct, and the Secretary of the Treasury came over to have a meeting with me, and Bob Rubin at the time, and he said, look, this is the Treasury Amendment, and the Treasury position is such and so. And I said, Mr. Secretary, I am fully aware of that, but that's not the position the United States is going to take in the United States. And he's like, who the hell are you? I'm the Treasury Secretary. And he went and talked to the White House counsel, and it was explained to him that actually we made the decision, not him. It was a little bit hard when I went back into private practice, and now had this sort of appellate practice rather than the trial practice I'd had before I went in, to have clients come in and say, we just lost a case, in this court, and the judges must have been on drugs. This is the worst thing that's happened to our company. It's completely indefensible. We need to take this to, you name it, the Seventh Circuit, the Supreme Court of the United States. And I'm sitting there thinking, boy, back in the day, I could have said, you are absolutely right. This is really important to your company, and you should have won this case. But I just don't think it's in the long-term interest of the coherent development of statutory law to really take this case to the Supreme Court. So, there were good things and bad things about it, but, I think most people who've been Solicitor General miss the opportunity to be able to take a much broader perspective than the interests of their particular client.
How about for you, Paul? What was the transition like for you?
So, on the one hand, I agree with everything Seth said. I guess I'd sort of make the case. There are some compensating benefits. I guess one way to think about it is like on the front end, before you get up to the podium, the Solicitor General job is great because you can, you're a monopoly supplier of legal services to your clients. And that's the main difference. So you can actually sort of tell them no. In a sense, Seth's overly generous because sometimes you'd look at these appeal recommendations and you'd be like, you totally deserve to lose. Right. You just took a dumb position. The court gave you exactly the result you deserved. In fact, I think they went a little light on you. And there's no way we're going to take this up to the Supreme Court of the United States. And that's a beautiful thing. And then I don't know about you, Seth, but it's great when you're the Solicitor General and you're sort of done with your brief, you file it. You don't run the final version by the client one last time so they can mangle some line or do some other damage. You just file it. So until you get to the podium, it's the Solicitor General job has it all over everything else. But as Leondra, I think, was alluding to this, when you're at the podium as the Solicitor General, you are responsible for kind of so much more than when you're up there on behalf of Ford Motor Company. And even like with respect to Ford Motor Company, if you're up there in a products liability case, the justices aren't really likely to ask you, well, what's the Ford Motor Company's position on climate change? But when you're up there for the United States, you really are kind of open, particularly if you're the Solicitor General, frankly, you're open to questioning about any aspect of the case. And so if you're taking a position about how to interpret regulations, they're going to assume that it's not just in the interest of the agency you're representing in that case, but that it's in the interest of the federal agencies generally. And if one of the justices, some of whom have been in the SG's office and sort of have their own views on this, thinks that your position is actually inconsistent with the interests of one or the other constituent agencies, they're not above sort of asking you about that. I'd been asked about, whether the United States position was cleared with the State Department. I mean, things like that. You're just sort of responsible for the entirety of the executive branch. And by the time you get to the podium, you may have, had to, get hired in the first instance. You may have had to have your, brief heavily edited in places. But by the time you get to the podium, it actually is quite simple. And I'll say one other thing about private practice that I do love, and it's something that I've missed the last 2 years. But if there's one disadvantage of being the Solicitor General is that your clients, if you're Solicitor General, sort of take being in the Supreme Court of the United States for granted. They've been there before. They're probably going to be there in a couple of years. It's not that big a deal. When you represent a private company and they get all the way to the Supreme Court, even the biggest companies only get there like once a decade, which means it's probably the first time in the institutional memory of the legal officers that you've been to the Supreme Court. And it's a big deal for them. Back in the day when you could go to the building, they were excited to go to the building when you sort of told them this is what's going to happen. We'll go through security, you'll get there, you'll sit here. Maybe we'll move a couple of people in the legal department in so we can get a couple extra people into the courtroom, a few other tricks like that. It's a big deal for them. And the nice thing is the court doesn't disappoint. Most private sector clients do feel that at some point as they made their way up through the system, they got a bad draw with some judge or some judges that didn't do the reading, didn't even look at our briefs. You hear that a lot from clients. And the Supreme Court never conveys that to the clients. They always, win or lose, they convey that they have really taken the issues incredibly seriously. They've done their work. They ask both sides really difficult questions. And, I really do miss that, not being able to have the clients with you in the court.
I would say, Leondra, I told you about the things that were deflating about being in private practice versus being Solicitor General. But one thing that is very gratifying and exhilarating, and to me, essentially is the reason why I've loved having had a private practice for the past, 400 years, is the ability to do pro bono and the ability, not that representing the interests of the United States as a Republican democracy is not pro bono. You do get paid, although
yeah, your spouse will tell you it's close to pro bono. Yeah.
But, you know, the ability to go back to a position where I could decide what kinds of cases and what kinds of legal issues and causes I thought were really important to improving the system of justice or improving democracy, and to devote myself to those kinds of things. I mean, the McCain-Feingold case is a very good example. As soon as President Bush was elected, I got involved with Congress in helping the bill writing committees draft this very important piece of campaign finance legislation. When it was challenged the very day that President Bush signed it on behalf of the congressional sponsors, I undertook the defense of this in a long trial and appeal, and it was really, really important to me, and I thought very important to the stability of our democracy. And similarly, I went back to what I had been doing since I started practicing law, which is representing death row inmates and youth, children, and teenagers caught up in the criminal justice system. And, that is a form of gratification of being in private practice that I think is well worth mentioning and has been super, super important to me.
So between the two of you, you've both spent a lot of time at the podium representing a variety of different clients besides the government of the United States. You've also seen a lot of different members of the court. You've seen a lot of changes at the court over time. And so I want to bring you to sort of the present moment, to this past term, and normally this is a pretty quiet time at the court. This is the period after the arguments have ended. We're usually, on pins and needles waiting for the opinions to come out. This year has been a little bit exceptional. And so I just wanted to turn to the two of you and ask you what your reaction was to the news of the leak of the February draft of the opinion in Dobbs, the Mississippi abortion case, and what that means for the court as an institution. Paul, do you want to?
Yeah, I mean, I can start just by saying, my reaction was, the word that just kept going through my mind was unthinkable. From the perspective, I clerked at a time when Chief Justice Rehnquist was the chief, and if there was one thing that Chief Justice Rehnquist could do is just scare the lights out of you. And he made a point, every incoming law clerk just, read them the literal riot act about, kind of no contact with reporters whatsoever. Confidentiality is just, the byword here. And, essentially if you sort of disclosed any of our deliberations, your legal career would be over. And over the years of watching the court since, they deal with these incredibly contentious issues, and for years and years and years, they just, they don't leak. Yeah, there's, a little something here, a little something there. There were some sort of warning signs over the last, decade. There were probably kind of more discussions with reporters after the term ended than I seem to remember from kind of earlier years. So you could say that the norms were sort of slipping a little bit, but the idea that you would have like a full-blown draft opinion sort of leaked from the court just seemed, absolutely unthinkable. And I mean, just sort of in terms of the effect on the court, I think it's profound, both short-term and long-term. In the short term, I mean, one of the things that, I don't think people are kind of focusing on quite enough is that, yes, the court will eventually issue an actual Dobbs opinion, and it'd be interesting, fascinating as a student of the law to see how much different it looks and, how the vote comes out and all of that. But that's just like one of 35 cases or something they still have to decide. And this is the time of the year. I mean, Larry Wallace, a longtime deputy, at this time of the year said, well, now it's their problem. For the lawyers, once the sittings are over, things kind of relax. But for the justices, this is really the crunch time. June 1st is the deadline for them to circulate their draft majority opinions. And they have all these outstanding cases. So there's so much work that needs to get done over the next month and a half. and the sort of internal dynamic has to be really frayed right now. So I really do sort of feel, I guess I really feel for the law clerks. I mean, I feel for the justices too, because they're stuck. I mean, they got lifetime tenure or life sentence, depending on your perspective. But the law clerks, this is supposed to be one of the best years of their life, and the next month and a half, I don't think it's going to be that pleasant for the law clerks. And then longer term, there's so many things that are probably somewhat fortuitous about the Supreme Court that I think make it function as an institution. And one of those things is the fact that they always end up saving the biggest, most controversial cases for the end of the term, and they often disagree with each other in very strenuous terms. And then they leave the country for a couple of months and go to nice places and think about other things, and then you really don't have to deal with each other for another sort of 2 or 3 months. And now they've got to sort of deal with each other and deal with all of this. And so, I think even in the longer term, this is, I think we will look back at this as something sort of as a watershed. I don't think this is just a single thing. I think this will really take a while for the institution to recover from.
So I agree with unsurprisingly, I agree with Paul's comments. I would just say, I have no doubt whatsoever. I mean, John Roberts may not be as terrifying and imperious as William Rehnquist was, but there is no doubt in my mind that, that the current Chief Justice does every bit as good of a job of impressing upon incoming law clerks the absolute obligation for complete secrecy and discretion. I am personally skeptical that the leaker in this case was a law clerk, but I don't have any more information than literally anybody else in the case, unless the marshal has, this afternoon uncovered who it was. I think this is a considerable blow for the Supreme Court as an institution in the public eye at a time when the Supreme Court the public's regard for the Supreme Court is at a very low ebb, certainly the lowest in my lifetime. And I think to some extent I would have said, as Paul said before it happened, that it was unthinkable. But I do think to some extent, whoever the leaker was, this reflects sort of a change in the internal dynamics of the Supreme Court itself, which seems as an institution looking at its members to be somewhat more brittle and acerbic than it has historically been and that the nation needs it to be. So, it's a sad thing. And, I think everybody was really shocked that it occurred and are worried about what this means for in the medium and long term for the Supreme Court in terms of the way the justices operate and in terms of the way the court is perceived by the public.
I wanted to shift gears a little bit and ask about another topic that has been much debated and discussed over the past couple of years, and the past term is no exception, which is the non-merits docket, which is sometimes referred to as the emergency docket, sometimes more recently referred to as the shadow docket. And I'm wondering if you can talk a little bit about sort of how you understand the controversy that exists about the docket and how you see the issue unfolding.
Well, just to level set what we're talking about, I mean, the Supreme Court, as most people are familiar, the Supreme Court sits en banc on all cases, and the norm, for very good institutional reasons, is full briefing and argument to consider the merits of the important statutory and constitutional issues that come before it. It's currently, referred to often as the shadow docket, refers to the emergency docket of the court. That is, the Supreme Court, like every court, has to deal with certain legal matters that come before it where there's just a decision has to be made, yes or no, right now. And there simply isn't time for full briefing and argument on the merits. That's a necessary feature of every judicial system. I mean, the paradigm, I suppose, was, there's somebody who has been convicted of a capital crime, is on state death row, has exhausted all of his direct appeals, petition to the Supreme Court, habeas corpus, federal habeas corpus is about to be executed, and files a cert petition or asks for a stay of execution pending a cert petition. And, it's filed at 3 o'clock in the afternoon and the execution is going to happen at 2 o'clock in the morning. And the Supreme Court has to issue an order either staying the execution or not, and we're obviously not going to have full merits briefing and argument. The controversy that has arisen is that over the past, I would say certainly since the beginning of the Trump administration, the number and character of cases and significance of cases that are being decided by the Supreme Court on its emergency docket in unsigned orders without even indicating who voted where and without briefing or any sort of plenary consideration has increased dramatically. Just between 2017 and 2020, the number of emergency dispositions that reflected, where the orders reflected dissenting views, very often 5-4, increased by an order of magnitude of 10. That is, it went up tenfold in 4 years. Part of that was because the Trump administration was particularly sort of insistent on going to the Supreme Court on an interlocutory emergency basis, much more than had been the case in the Obama administration, the Bush administration, the Clinton administration, the Bush 1 administration. It's troubling as an institutional matter because one of the things that the Supreme Court does for the nation is, not just to be the ultimate arbiter about what the laws and Constitution of the United States mean, but to provide the reasoning behind that and the assurance to the public that in rendering these highly consequential decisions, they've given it their best. They've done, what Paul was describing. You get done sitting through an oral argument on the merits where there's been briefing. It's very hard to, you may not agree with what the justices have decided, but very few parties feel like, or the public feels like, each side didn't get a fair shake and wasn't heard on the case. And that's not happening in a number of these cases. And so Paul may disagree with me about either what I perceive as sort of a serious, I think, departure from norms or what constitutes some of the, there are plenty of cases. But Paul, maybe you'll talk about the stay motion that you filed, I don't know, today, yesterday, or Friday, as recently as Friday,
yes.
In the Florida sort of internet matter where, I think people can debate whether Paul's view or Governor Abbott's view is about regulation of internet service providers, internet platforms is right. I happen to think that Paul is right. There will also be differences of opinion about whether this is something where issuing a stay truly constitutes an emergency. But I think, to my mind at least, there have been decisions by the Supreme Court, very consequential, decided on the emergency docket, that to me, I just don't get the emergency. And that, one of the ones that principally comes to mind is the court's issuance of a stay of an injunction imposed by a 3-judge district court sitting in Alabama that was adjudicating a constitutional, a challenge under Section 2 of the Voting Rights Act to the redistricting map enacted by Alabama. The Supreme Court granted cert, and it's going to be heard, briefed, and argued next term. But, in, December or January, the court on its emergency docket vacated a stay of the injunction of a unanimous 11th Circuit 3-judge court, meaning that a map consistent with the established meaning of the Voting Rights Act can't be used in the November election. There was a lot of criticism of the court's summary disposition in the whole women's health case that provoked some pretty vociferous dissents, both in the Alabama case and the whole women's health case, not only from Justice Kagan, Justice Sotomayor, and Justice Breyer, but also the Chief Justice about the propriety of using this sort of emergency docket. And so that's what it is. That's what the debate is about. You now have my view that the court would, and the nation would be much better served if the court in cases of questionable emergency would consider the case, and full merits briefing and argument. And I think people ought to bear in mind that, throughout its history, where exigent circumstances really presented themselves, not like the person is going to be executed in 3 hours, but for example, the Truman Steel seizure case, or Bush versus Gore, where the court has, or even, I'm trying to remember what it was this term, but a case this term where the court basically said, okay, we're going to have extremely expedited briefing and argument in this case. You've got 10 days to file your brief. The other side has 7 days. We're going to hear argument 4 days later. That is far preferable, from my point of view, than just having, an unsigned order issued without the benefit of briefing and argument saying, this is the way it should be.
Yeah, and, we may disagree on some of the particulars, and we could almost certainly disagree over whether a particular instance of it was a good or a bad use of the sort of emergency docket. But, I don't know that we really disagree that much, because one thing I hear you saying, and certainly I will say it in case I misheard you, but, the problem isn't with having an emergency docket.
Right.
Every appellate court needs an emergency docket, so you literally can't function without one. And to me, I don't think it really advances the ball to call it the shadow docket, because that sounds inherently sinister. And so, I think it really then just becomes a question of, is the court using the emergency docket sort of too much, or in the wrong cases, or in cases where it's sort of a faux emergency? And so I think that's, I hear you saying that, and I think that's right. And then I think we can actually have, kind of a more meaningful debate about which cases are the sort of faux emergencies and which aren't. And some of that is just going to, at bottom, just maybe be a disagreement about what you think is an emergency. I might be more sympathetic to the view that, if somebody's got a religious liberty claim about a vaccine or something, that it's an emergency. They're either going to have the vaccine or they're not. So you can't really just say, well, we'll hear you in 9 months and we'll see how that, the inoculation's going. But I think that's really where the debate should be. How are they using it? And then I think if you shift the debate there, then you can start to talk about whether the sort of greater use of the emergency docket doesn't itself have some root causes that are really what we should be focused on. And my own hobby horse, I'll admit it, something I didn't like even when it happened once in a blue moon in the Bush administration. But then it's happening more and more often in every administration, and I have this belief that separation of powers problems ultimately get resolved when both parties see their ox gored, and so I have this hope that we're at the point where sort of both parties have operated the presidency and been sort of tormented by nationwide injunctions. So maybe we can actually make some progress and agree that nationwide injunctions, probably like emergency dockets, like they have to have some. There are certain circumstances where you need them, but I do think that nationwide injunctions put so much pressure on the whole system And they're ultimately part of the reason I think the Trump administration went to the Supreme Court more often than previous administrations, because they were also subjected to these nationwide injunctions. And in my view, part of the reason they're so problematic is that we talked a lot about the Solicitor General's office. One of the big things you do in the Solicitor General's office is, we did have this great luxury of saying, yeah, you're probably right about that, but the facts of this case are terrible, and we can sort of tolerate having some questionable law in the Fourth Circuit, and we'll continue to fight this issue elsewhere. And if a circuit split, if we get to the point where the Justice Department has persuaded a Court of Appeals that we're right, then we can, kind of go up to the Supreme Court, and they can resolve the circuit split. That's kind of what they do. And if there's a policy that's enjoined nationwide, then that kind of pretermits the whole process and puts a lot of pressure on the system. I had a case just during the Trump administration where this case was working its way through in the Third Circuit and the Ninth Circuit. And at the point that the Third Circuit upheld the district court's nationwide injunction, the Ninth Circuit said, oh, well, then we're not going to hear the case because there's already a nationwide injunction. So, we'll abstain. We'll abstain on the injunction stage, and we'll wait until the merit stage before we even issue a decision. Well, not surprisingly, the Supreme Court, kind of having seen a nationwide injunction and basically the possibility of a circuit split eliminated, took that case up. So I do think things like that are part of the problem. Only other thing I'll say about this is I do think the court is sensitive to it. And so, they did, with the vaccine cases, they didn't definitively decide those just on the emergency docket. They had oral argument, even though it was technically, I think the ultimate decision was written by Justice Curiam. So they did decide.
That's per to you.
Yeah. They did decide it as an application, not on the merits, but they still had argument.
Yeah,
on
and
this,
that's
like stay in Mexico. Maybe that's what you were thinking about in the Stay of Mexico case. They kind of expedited that a great deal so they could hear that case. So I do think the court is hearing it. That doesn't mean they've solved the problem, but I think they're sensitive to the criticism.
Let me say, before we move to, well, of course, subject to the diktat of our moderator, before we move to nationwide injunctions full square, let me just say a couple more things about the shadow docket. I agree with Paul that the disagreement is what constitutes a real emergency. This is not under federal law, this is not a Rorschach test. There's an there are well-recognized standards for district courts, Court of Appeals, and the Supreme Court applying temporary injunctive relief, whether it's a stay or the vacator of a stay or the issuance of a TRO or a preliminary injunction, and that is it is temporary emergency relief is meant to be an extraordinary event. The Supreme Court has said this many times. It requires a very high showing by the movement that includes demonstrating a likelihood of success on the merits when and if the case is given plenary consideration, irreparable injury that will be suffered, which, in the case of the vaccine mandate is pretty much satisfied, the balance where the public interest lies, and the balance of hardships, pro and con. And one of the things that has been disturbing about, in my view, about some of the applications of the emergency docket by the court recently has been, as pointed out by the dissenters, including the Chief Justice, the sort of abandonment of analysis, apparent abandonment of the analysis of those principles. In the Alabama voting rights case involving whether or not the state legislative districting process reflected an egregious instance of racial gerrymandering, the state itself, in its stay papers, wasn't making an argument on the merits. Their argument on the merits was the Supreme Court should overrule its governing precedent in Thornburg versus Jingles. There was no argument that the three federal judges who had considered this were misapplying the Supreme Court's precedent. And so I think hopefully the court is sensitive. The chief certainly is sensitive to the criticism of the overuse of the emergency docket. But I think, a fair application of the sort of four factors that have to be satisfied or considered by any federal court that is asked to grant emergency relief would be a useful way to sort of bring things, I think, back to the norm. The other thing I'll say is, interestingly, that there is some interaction between the increased prevalence of nationwide injunctions and the much broader definition by the Supreme Court of the metes and bounds of its emergency docket. There have been, I think within the last year or maybe 2 years, there have actually been congressional hearings on both of these phenomena. And I didn't attend the hearings, but I've read some of the testimony on both sides. And one of the things that's sort of, I think, notable about those two hearings is, in the hearing about the shadow docket, there was bipartisan, if you look at the comments of the members of the House committee that heard it, there was sort of bipartisan support for the notion that, these unsigned, unexplained summary decisions were not a good thing. The preponderant feeling and the preponderant notion of the people who, the sort of bipartisan group of witnesses who testified was this looks like it's gone too far. In the hearing on nationwide injunctions, one of the things that was really notable was that most of the witnesses and most of the congressional members who talked about this were of the view that, on the one hand, there were good reasons for nationwide injunctions. On the other hand, and there were good things about having a nationwide injunction, and on the other hand, there were not good things about having nationwide injunctions. In other words, much less of a sort of consensus, at least in those congressional fora, about how big the problem was and whether it reflected a need for change in one particular direction or not. Now, I should say that since you're hearing from two former Solicitors General, and in a program being moderated by a former Deputy Solicitor General or Acting Solicitor General or all of those things that Justice Kruger was, Solicitors General hate nationwide injunctions. I mean, this is just bred to the bone. These nationwide injunctions are issued in response to executive orders and agency rules almost exclusively. These things rarely come up in the context of a private dispute that doesn't involve the validity of a federal order. And when they are issued not as a way of clapping the federal agency or the president on the back, but enjoining what's been done. And so institutionally, the Solicitor General's office is not really of two minds about the validity of nationwide injunctions. I think Paul and I can agree that there are some very undesirable things about a single district judge being able to enjoin federal policy, federal law throughout the country without the kind of percolation that applies. There are lots of odd questions that come up when this happens about, the doctrine of the application of non-mutual collateral estoppel, which doesn't apply to the government, but on the other hand, sort of does by definition if there's a nationwide injunction. I think, and in trying to think about this, I think that there is a distinction. It doesn't provide the answer to whether it's appropriate in one case or not. but it is a very material factor in determining propriety, whether what is being enjoined is something that is not yet in effect, has just been proposed, and doesn't reflect current practice and current standards, or something that has been in effect and has been the law, and there ought to be a much greater presumption against a nationwide injunction in the latter instance than the former instance. You know, the phenomenon that Paul was discussing about, you know, the last two administrations, the increase in the nationwide injunctions, is certainly true. And you just look at when President Trump and President Biden came into office, on the very first day, they issued, I don't know, a dozen and a half executive orders saying, you know, my predecessor was on the wrong course and, you know, had policies that were utterly destructive of everything that anybody believes in, and I am heretofore, using my executive power, issuing orders saying A, B, C, D, E, F, G. Those were a clarion call to opponents to seek a nationwide injunction, because they were, by definition, proposing dramatically and single-handedly, without congressional consideration or even APA processes, just wholesale changing enforcement policies. Now, maybe that's the world that we are increasingly coming to live in our, you know, just so terribly divided political world, but.
So we're getting increasingly insistent messages about our timing. I'm sorry to cut off this conversation, because I think these are important issues and they're fascinating. But want to make sure that I also fulfill my promise to allow questions from the audience. So if there are any questions, please come forward to the mics and we will hear from you. As people are assembling, I do want to ask you one last sort of wrap-up question about the Supreme Court term, which is just to ask you to look ahead a little bit, and, you know, sort of as you're looking towards the close of this term, as opinions start to come down. We've already talked a little bit about the Dobbs case, but sort of can you preview for us, you know, sort of what are the things that you're particularly anxious to see coming from the court? What do you sort of anticipate coming out of the term that follows?
Well, I'll give an answer it's a little bit of a non-answer, I'll admit, but you know, so one of the things that will be true about the court in the future is that it won't have Justice Breyer on it, and you know, it'll have Justice Jackson on it. You know, right now we have this interesting phenomenon. You know, the Solicitor General from time to time is referred to as the 10th Justice, but now we have an actual 10th Justice. And so Justice Jackson will be on the court, and that will be historic and will change the dynamic of the court. But not having Justice Breyer on the court will make a big difference. I mean, I think he is the current court's sort of foremost pragmatist. I think he's the justice that kind of can best write an opinion that kind of brings the court together and says that the following 4 factors taken together resolve this case without necessarily having a single factor test that divides the court. So I think, kind of looking forward to the court, I sort of look backwards a little bit and think, what a great career of public service, and what a kind of, you know, a distinctive justice that we're going to lose going forward.
I mean, in terms of, let's let the questioner ask the question. If we have some pause, I'll tell you what I'm looking forward to in terms, or not really looking forward to in terms of upcoming decisions of the court.
Well, that's a very nice segue. Ronald Krozensky, Tuscaloosa, Alabama. You've both spoken at length, all 3 of you have spoken at length about the legitimacy of the court, the importance of its role in our system of constitutional government and rule of law. If one assumes that the opinion that was leaked to Politico is in fact the final result, even if it's not the final opinion, what do you think the effect of the reversal of Roe v. Wade after 50 years will be on the way the Supreme Court is viewed by we the people as a governing institution? Will it be to the good, to the bad? Impossible to predict. I'm curious as to what all 3 of you think. the abolition of a woman's right to reproductive choice will mean for the perception of the court's legitimacy. Thank you.
Well, he said he wanted to hear from you too, Leondra.
I'm just asking the questions here.
I mean, I don't know if I'm speaking for Paul. I don't really feel comfortable, with all due respect to the questioner. I don't really want to answer that question. I don't like to express opinions about cases that are pending before the court before they're decided. It hasn't actually been decided. And if I were giving an honest answer to the question, it would be something like, some people will see it as a return to legitimacy, and many, many people will see it as a reflection of the decline of the court's legitimacy as an institution. But I don't want to talk about, undecided cases, however apparent it seems what the disposition would be.
I think that's good counsel, Seth. And I'll just amplify it by saying, my own view is that, as people who care about the court, the focus at the moment really should be on the leak, and there's going to be plenty of time to talk about whatever opinion emerges, and people will be able to address this question at length, and people, will have differing views, but we shouldn't be having this conversation now. The draft opinion shouldn't be subject to these, substantive critiques, because we shouldn't have it. I do feel, I guess my own view is that, as I alluded to, I think one of the things that sort of, judges and lawyers have almost a responsibility to do is try to explain to people how, the court system is not politics by other means. And in doing that, kind of historically, it's been helpful to me to be able to say, look, the Supreme Court isn't like the other branches of government. It doesn't leak. And look at Congress, look at the executive branch. So I guess that's why my sort of just amplifying on Seth's non-answer is that the thing that right now, and I think it's why we discussed it when we first started talking about the court, is that it's this leak is just from an institutionalist perspective, just so damaging to the court that I think there's going to be enough to talk about with the opinion in due course. But in a sense, I don't think we can talk about sort of the leak too much, because I think it really is institutionally a very big deal.
I mean, in terms of, we don't seem to have a massive rush to the microphones here.
Well, it probably didn't help that we didn't answer the first question.
Can we commit that we're going to answer this?
These are reasonable people. They respond to incentives.
Let's commit up front, Paul, that we're going to answer the second question.
Well, I'm not sure I'm willing. Okay, you can. Because here it is.
And it's coming from a provocateur. There's no doubt about it, Larry.
Larry Stewart, Florida. So without getting into the case, a specific case, you all have referenced already that the legitimacy of the court has declined significantly in the public view in recent times. Do you have any ideas or suggestions of something that the court can do to pull itself back up? Because I worry that if the public loses confidence in the court, then that is going to be a tremendous blow to democracy in this country.
So I actually will. I have an idea, and you'll like it. And it's going to sound entirely self-serving.
Does it involve Justice Merrick Garland?
No, it doesn't. It doesn't. But you're still going to like it. I think, and again, it's going to sound self-serving, and it is. But the court should take more cases on the merits. And the reason I think that is because, the court, it's sort of in the water up there that, like, well, we don't take cases for error correction, and we only take them to resolve splits. But, every once in a while, you take some cases for error correction, and if you took a few cases for error correction, a funny thing would happen is there's certain errors anyways that you would correct unanimously. And then the public would see the court deciding a greater percentage of its cases. It's already a pretty sort of significant percentage in practice, but they'd see the court deciding a greater percentage of their cases unanimously. The cases that divide the court and divide the nation on abortion, on race, on guns, whatever they are, would become a smaller percentage of the docket. And I actually do think it's not a complete solution, but I actually think it would move the needle in the right direction, and I think also would be kind of helpful. When all 9 justices, who everybody sees disagrees about certain issues, can agree that a certain state statute is unconstitutional, or a certain punitive damages award, whatever it is. But just some of these cases where there's a pretty obvious injustice, there's not a circuit split, take the case, add it to your docket, have a bigger sort of denominator of cases, more of which you agree on. I think that would actually send a positive signal.
I mean, I agree both on, for the reasons you've given and also for the reasons that we otherwise would like that, which is that one of the things that we do in life is to handle cases in the Supreme Court. And, the marked decline of merits cases in the Supreme Court to, from 150 a term to now 60-something a term is pretty dispiriting for Supreme Court lawyers. But I will say, Larry, one of the things, I think we've already covered one of the things that I've talked about, which is I just think that the Supreme Court should be showing its work on more of these cases. Maybe amounts to the same thing, but there are so many of these cases that are disposed of by orders that could and should be the subject of plenary consideration. That would help. I think, unfortunately for the Supreme Court, I think some of the things that have really contributed to the sort of widely reported decline in popular satisfaction with the Supreme Court or reverence for the Supreme Court are things that have been done in the political sphere that the justices themselves are not responsible for. And that includes, of course, the confirmation process, nomination and confirmation process. But that said, there certainly are things that the justices could do and should do to get back to a perception of regular order.
Well, on that note, I think we are now well and truly out of time, but I hope you will join me in thanking our 2 speakers this afternoon.